Hancock County families are fighting to stop some of their land from being taken to make way for railroad tracks. This is over the use of eminent domain to seize private property. That's the government's right to use private land for public use. The Georgia Court of Appeals listened to arguments from both sides yesterday. Sierra Cummings has details from the courtroom.
Welcome, everyone.
This latest appeal hearing comes after a judge last year gave Sandersville Railroad Company the right to take 9 properties, all for a new railway that stretches 4.5 miles in Hancock County. Eminent domain in Georgia gives the government or its agent the right to take your land if and only if it's for public use. Wednesday afternoon, the lawyers for the landowners argued a private railroad is not of public use or public benefit, instead financial gain for the company. The rail company, however, argued the train will haul goods that ultimately serve the community, adding they only need roughly 3 to 7% of each owner's property.
This line will benefit only Sandersville Railroad itself and its few customers. But the Georgia Constitution does not allow this kind of taking. Neither does the U.S. Constitution nor do Georgia statutes. Georgia courts have never held that a closed system like the Hanson Spur constitutes a public use.
It would be like saying, okay, MARTA condemnations aren't for a public use because you have to pay MARTA's fare and comply with MARTA's rules for ridership in order to ride the system. That's not a public use because you have to pay to use it. Similarly here.
The Georgia Court of Appeals will rule on this case in the coming weeks. Meanwhile, the project still remains on pause for now. The Institute for Justice, the nonprofit firm representing the landowner, says it's prepared to take this all the way to the U.S. Supreme Court.